Such a good song. I hate to interrupt it. But ladies and gentlemen, welcome to the Weekend Court Review with Lone Wolf Uso. Welcome to Weekend at Wolfie's. Ladies and gentlemen, I have a special set of dockets in store for you today with the reemergence of the Titans, the great Judge DiSanto, and the great Judge McNally. I am so excited to share this with you guys. We also have a fan favorite attorney appearing in front of DiSanto a little bit more than once, and it's oh so good to see DiSanto again. That's all I'm going to say, and I'm shutting up for now because I want to listen to the rest of this song. Ladies and gentlemen, welcome to the Weekend Review. We're getting it started. We got 2 hours of dockets ahead. They're all good. Hope you enjoy.
All right, this is a matter of the state of Michigan versus Thomas Connelly, 241963.
Good morning, Your Honor. Good morning to your staff. May it please this most honorable court. Edward Martel, P85051, on behalf of Thomas Connelly, who stands to my right. Sir, please state your full name for the record. Thomas Patrick Connelly.
Hi, good morning, and good morning, counsel.
Good morning, Judge.
And today's date scheduled for the probable cause conference, and you're asking for adjournment?
Judge is correct, Judge. I am newly detained, seeking any and all discovery at this time. Judge, my client has been advised of his right to an examination within 21 days. At this time, he wishes to waive that right in light of our request, Judge.
All right, and so does December 12th, would that be sufficient, counsel?
Judge,
Next Thursday? Or the 19th?
I would prefer the 19th, Judge. I want to have enough time to put together a package for brother counsel towards a resolution.
Okay.
19th, please, and thank you.
Okay.
We can do 8:45.
Does 8:45 work, counsel?
Absolutely, Judge. Thank you.
Okay. All right, and then let me just go over some of the bond conditions because your client was arraigned out county. Wait, what was your last name?
Martel.
That's what I thought, but it's showing Nasser, but you're in his office.
Me and Nasser are together now.
Oh, okay, all right. And so, all right, I'm just stating that because the appearance only shows Mohammed Nasser, so I didn't know if you just want to place on the record that you're standing, that you're the attorney of record with your client's consent.
Well, we both are co-counsel, and certainly Mr. Connie is aware of that, correct?
Okay, all right.
And Judge, if I may just kind of preemptively highlight a couple of things. Number one, I've discussed with Mr. Connelly that, certainly no drugs or alcohol or any type of weapons while he's on probation. I have spoke with him in depth. He did indicate in full and complete truthfulness and candor that he did smoke marijuana previous to this, so it may still be in his system. However, again, he's advised me and I've advised him of saying that he cannot and will not participate in any substances while during his bond conditions.
Okay, and so Sir, do you have a valid prescription for marijuana?
He does not, Judge.
No. And when's the last time you used it?
Before I was taken into custody.
Okay. Okay, so what I'm going to do is I'm just going to clarify that there's no alcohol or drugs that are not prescribed. Do you have any prescription medication, sir?
No, I do not.
Okay. And there's also a civil infraction 24W94706 that accompanies this as well. So I just, for the record, need to state that we're handling that as well.
Yes, Judge.
Because it's gonna continue to follow. The case here. All right, and so the court's going to order bond and conditions are continued with that brief amendment. All right, we'll see you back on the 19th at 8:45.
Thank you, Judge. Always a pleasure. Thank you.
All right, you as well. Okay.
Your Honor, may I approach briefly?
You may, let's go off the record.
I just need Mr. Garcia's file, Your Honor, for the DP. Here. Thank you.
You're welcome.
You want to also have Mr. Robinson and another sole plan.
Yes. All right. We are on the record in the matter of the state of Michigan versus Elijah Robinson, 241691.
And once again, Your Honor, good morning to you and your staff. May it please this most honorable court, Edward Martell, P85051. On behalf of Elijah Robinson, sir, please state your full name for the record.
Elijah.
All right, thank you. And today's the date scheduled for the probable cause conference. Your client was arraigned out county and counsel.
Thank you, Judge. Judge, today's daytime probable cause conference is stated, have discussed with my client that he has a right to an examination within 21 days. Similarly to the last case, Judge just recently retained, seeking some additional time to get up to speed and work towards a resolution. In light of saying my client is waiving his 21 days at this time, is that correct, sir?
Yes.
In light of our request, Judge, please and thank you. And I would ask to come back on the same day if at all possible.
No, we're in the habit of making it more difficult for you. Yes, we will adjourn this to December 19th at 8:45 a.m. And are you currently on probation or parole, sir?
No, ma'am.
How'd you get here today?
What?
From Detroit?
It's not, it's like 2 miles away.
Sir?
Fortin, our drive is like 2 miles away.
Well, it's more than that, but you're telling this court that you walked from there this morning
Yes.
and that your vehicle is not outside in the parking lot.
I'm not allowed to drive.
I know that.
Yes.
That's why you have a charge here, because it's alleged you were driving while you're not allowed to drive.
Right.
You wouldn't be the first one that shows up to court driving when they're not supposed to, so
My vehicle is not outside.
is anybody's vehicle that you borrowed outside?
No vehicle is outside.
You don't have any keys in your pockets?
I do have keys, but they're to the house.
Okay, let me see.
They're in my coat.
Okay. Let me grab the gun.
And Judge, I certainly can't speak to that, but I can speak to the fact that I will make sure that he Ubers or gets necessary transportation when we exit this building, of course.
There's a car key on there.
Yes, but I didn't drive.
So why do you have a car key on here, sir, if you don't drive?
It's been on there for a long time. My car was a Challenger, and that's still a Chevy. That's my wife's car, spare car key.
Right? If you can't drive, why is that a key ring?
It's been on there for a long time. I promise I
I
didn't.
know, so my point is, take it off. You can't drive, take it off.
You understand that, sir?
I understand.
But something tells me that you drove here.
This is why I dress warm.
Thank you, Judge. So acknowledged.
All right, bond and conditions are continued. Sir, if you're driving out of this parking lot, you will be arrested again.
Mr. Robinson, you understand and appreciate that, correct?
Yes.
Thank you, Judge. Thank you, Judge.
Thank you.
Have
Have a good day. All right, we'll see you back in 2 weeks. Thank you. Okay. We are on the record in the matter of the state of Michigan versus Ralph Salinas, 241474.
Morning, Edward Zelak for the defendant. This was better than reruns of Hollywood Squares, Your Honor. I enjoyed it, really is. Mr. Salinas was going to be the narc on that one, but I said the judge could figure it out for herself.
Oh, no, narconologist.
No, he just told me who drove into the courthouse.
Oh, I figured as much. So that's fine.
Well, I credit Mr. Salinas. This is the first time that he's told me something that was true. So.
I know what counts here.
Judge, we have nothing else to add for the pre-sentence report. Apparently, he's been accepted into the Veterans Court, and the court's been very generous to Mr. Salinas. We'd ask the court to adopt the recommendations.
All right, and sir,
Yes, ma'am.
we've met with 28th District Court Veterans Treatment Court, correct?
Yes, ma'am.
And
Yes, Your Honor.
what's a Chapter 10 discharge?
Fighting with Sergeant Rangel.
Okay.
Phil Great.
But you're still eligible to participate in the Veterans
Oh, yeah.
Treatment Court? Okay, all right, I just hadn't seen that before, so I wasn't sure what that was. All right, and sir, the court will order you to 24 months probation, comply with all terms and conditions of the 28th District Court Veterans Treatment Court. So, what I'm going to state, sir, is that I'm sentencing you to 24 months probation for purposes of these proceedings. If you complete the program successfully within the 24 months, you don't have to continue on until that 24 months expires, okay?
Yes, Your Honor.
All right, anything else, counsel?
No, Your Honor, he'll need some time to pay the fines.
Yes.
And I'm not sure how much you need, but
I'm going to set those fines right now. All right. The court's going to order a $750 fine, $100 screening assessment fee, cost of prosecution $300, crime victim assessment fee of $75, justice system assessment fee of $50. $1,275. There are also program costs that you're going to have to pay, but you'll have to pay those over the 28th District Court. All right, and you did post a bond here, correct?
No, Your Honor.
It was a personal bond. And so how much do you have to pay today, sir?
$500.
Okay.
wow.
Mr. Zelmak's surprised, I think that you owe him money, so,
Whether it hits $500.
oh.
Sorry, Judge.
So on your balance of $775, sir, how much are you able to pay per month and what days of the month works best?
First week of each month, Your Honor, and then, well, can we break it up into like 3-4 months? The balance.
Okay. So let's start that. Can you do the first Friday of January? No, let's do the first full week of January, which is January 10th. That's the second Friday. That still gives you time, that still gives you money that you can pay your attorney, correct?
Yes, ma'am.
Okay.
Your Honor.
All right. I'm not sure what the program costs are, sir, so just be aware that you have those costs as well. Okay. All right, thank you. Maybe you can email into them too. All right, sir, good luck to you. If you were to test today, what's in your system?
Diabetes medicine, Clipperide.
Okay. All right, sir. Please have a seat over in probation. They'll give you your paperwork, okay?
Thank you, Your
All
Honor.
right, good luck.
Judge, you'll be delighted to know that his wife drove him here today.
I presume so. She's here, so.
4 years she's had my back, Your Honor.
Okay, well, make sure that you're getting it together so we can have her back.
Thank you, Your Honor.
All right.
Thanks for
have a good
addressing the
day.
court, appreciate that. You.
Thank you for dressing very well for court. All right, Mr. Robinson, show back up yet?
You can see a chart.
Oh, no, he's supposed to be in person. Okay, we're going to recall the matter where's Mr. Martell? Oh. We're going to recall the matter of the state of Michigan versus Elijah Robinson, 241691. Mr. Martell?
Thank you, Judge. Good morning once again, Your Honor. Edward Martell, P85051 on behalf of Mr. Robinson. Sir, state your full name, please.
Elijah Robinson.
Mr. Robinson, you are to come back in person. That is what this court ordered. Because you violated this court's order. You drove out of the parking lot. You were in a Chevy minivan. So do not try telling me otherwise. You had a white female in the car as your passenger. You are to come here into court with somebody else driving you. And you are to report here to court in 45 minutes. You're to be here by 11 a.m. Counsel, can you zoom back in at 11 a.m.?
I can. Mr. Robinson, reserve any arguments for 11 a.m. Please do not speak on the Zoom. Yes, Judge, please and thank you. I will be available via Zoom.
Thank you. Mr. Robinson, you are to be in person in 45 minutes at this courthouse, not driving a vehicle.
I gotta walk back up there. That's gonna take longer than 45 minutes.
Do not, sir, listen. Do not tell me you walked here the first time again, because I am not dumb at all.
And Mr. Robinson, I would advise you not to speak at this
You
time.
certainly have not gotten back to your home already for your over 2-mile walk that you claim that you did.
I just got dropped off.
Sir, you better stop while you're ahead.
I'm telling the truth.
Mr. Robinson, I would advise you not to speak at this time.
Okay.
Some other way, but you're to be here at 11 a.m.
Thank you, Judge.
Thank you.
2 hours later.
And we are going to recall the matter of the state of Michigan versus Elijah Robinson, 241691.
Judge, if I may?
Yes, counsel.
Thank you, Judge. Good morning, Your Honor. Once again, good morning to your staff. Edward Martell.
I'm sorry, are you Mr. Robinson?
No, I was just.
No, sit down. I'm sorry, counsel. Your name, please, your appearance for the record again, please.
Thank you, Judge. Edward Martell, P85051 on behalf of Mr. Robinson. Mr. Robinson, please state your name for the record.
Elijah Robinson.
Okay. Sir, you are here. This court called you back because you were on the record and you insisted you did not drive to court. You insisted you walked the 2+ miles from your home. Is that accurate so far?
Yes.
Okay. Would that be accurate, counsel?
Yes, Judge.
Okay. Please remove your hands from your pockets. I was very clear, at least I thought I was very clear, that you were not to drive a motor vehicle. You were not to drive out of the parking lot, which I suspected, correctly it appears, that your vehicle was in the parking lot. You insisted that your vehicle was not in the parking lot. It was your wife's extra set of keys. Am I accurate so far?
Yes.
Yes, Judge.
So imagine my non-surprise when I was told that you did in fact have a vehicle in the parking lot, and you did in fact enter into the driver's side of the vehicle, and you did in fact drive out of the parking lot. I'm pretty positive I said, don't drive out of the parking lot because you will be arrested. Did I not tell you that?
Yes, but I never drove.
Sir, you are on very, very, very shaky ground right now. Because my court officer, the one that was working the door, saw you get into the driver's side of the vehicle and drive off. So you have your friend that was in the car that was in the passenger side, correct? He's here.
No.
No? Who's the gentleman that's here that was trying to walk up here with you?
He's the driver
The one that just drove you here?
that dropped me off and drove
Okay,
me
good,
back.
we're gonna find out. Sir, come up this way, please. Gordy, can you please have Mark come in here, please? Sir, what is your name for the record?
Nicholas Gendron.
Please spell your first and last names.
NICOLASGENDRON.
Good. Please raise your right hand. Do you solemnly swear from the testimony you're about to give this
I
man the
swear.
truth, the whole truth? Don't interrupt me. Do you solemnly swear from the testimony you're about to give this man the truth, the whole truth, and nothing but the truth?
Yes.
Okay. Counsel, I understand that this is not something that you had on your calendar today, but since your client clearly violated bond and clearly lied to this court's considering revoking your client's bond or holding it in contempt. So I'm holding this impromptu hearing.
Understood, Judge.
That's the tether.
Judge,
That is the tether.
Okay, is somebody talking to you on the tether? You have to respond to them.
I can't make it out. It's,
Just let them know that you're in court. Otherwise, it's going to continue to interrupt the record.
I'm in court. I don't think it's like a person talking. It's like recording.
Okay. So, I'm sorry, sir, can you spell your last name again, please?
GENDRON.
O-N?
Yeah, ON.
Okay. All right, and so were you here earlier today?
Yes, I was here this morning. I actually brought my cousin Thomas Connelly in because he needed a ride because he lives in Harrison, Michigan, 2.5 hours away. I was sitting in the lobby, and when they came into court this morning, I had walked out to the vehicle. When I got to the vehicle, he come out with my cousin and the attorney, and he asked if he needed a ride because he was gonna have to walk. I then drove him. I had my aunt's car keys. You guys can come out and look at the vehicle.
Hold on, pause. Hold on. What kind of vehicle do you drive,
A
sir?
Dodge Caravan. It's my aunt's car.
What color is it?
Black.
Okay. Mark, can you please state your name for the record, please?
Mark Kuziak.
Please raise your right hand. You solemnly swear from the testimony you're about to give this matter the truth, the whole truth, and nothing but the truth.
I do.
Okay. And so you were working the door a short while ago, correct?
Correct.
And so I requested after Mr. Robinson's case was done, if you could watch to see if he in fact drove away or not.
Correct.
So did you see Mr. Robinson, this individual here, leave the courthouse?
Yes.
Okay. And did you see Mr. Robinson get into a vehicle?
Yes.
What kind of vehicle did Mr. Robinson get into?
It was a dark colored minivan.
Okay. Where did you see Mr. Robinson enter the vehicle?
On the driver's side. The driver's side was facing west. It was parked in the south lot. It was about 4 or 5 cars back in the first row.
Okay. How many people did you see enter the vehicle?
2.
How many people, who did Mr. Robinson walk out with?
A white male, approximately 5'8", with a dress shirt and bald head.
Okay. Did you see this individual that's here in the sweatshirt at all in the courthouse?
Not when I was here earlier.
Okay. And Mr. Gendron, you're testifying that you were here in the courthouse?
Yes, I walked in, and then when they walked in, I walked out. Also, there's a car seat on the right back seat that he actually had to move to get into the driver's side. You can go out to the vehicle and look at it right now. There's a car seat in the back seat. I drove him to actually High Street in Southfield where I dropped him off at.
And so how did the two of you end up coming back together?
So, like I said, I drove my cousin. They actually were in jail together. He had gave him his attorney's number, so they had the attorney and they walked out together. And he asked if he could get a ride. I gave him a ride. I don't even know who this is.
Right, so how is it that you brought him back? If you don't know who he is, how did you bring him back?
He had my cousin's phone number. And he asked if I'd come back with him so he didn't get in trouble. And I figured it wasn't fair to him that I drove him home and he was getting in trouble, you know? I gave him a ride. I honestly don't even know who he is. Never met him a day in my life. Today was the first day I met him.
And so, Officer Kuziak, you saw Mr. Robinson get in the driver's side. Do you know if it was in the front or the back?
I couldn't be 100% sure. It looked like the front. It was closest to the I-beam of the vehicle, so closer to the front by the window glass. I was actually parked in like the third or fourth spot facing this way, and he got in behind me. He even had to flip the seat up to get in because it was folded over for the kids in the back seat, minus children. I think there's actually a couple of individuals also that are out in the waiting room that were still here this morning that seen me walk in. I talked to the one guy because your guys' doors were locked until 8:30 to be let in. He was standing in the little waiting room before he actually come into the courthouse.
And your testimony is, sir, Mr. Gendron,
Yes.
that you drove both Mr. Robinson and Mr. Connelly out of the parking lot.
Yes, 110%. No questions asked about it. It's my aunt's vehicle. Like I said, I don't even know this name at all, literally.
Mr. Martel, do you have any questions for Mr. Gendron or Officer Kuziak?
I do not, Judge. Just elocution when appropriate. I don't want to, be a witness to the case, but I had limited observations that I can attest to when the court is ready.
Officer Kuziak, when the vehicle drove out, did the vehicle at any point come toward the courthouse itself or go straight towards the street?
It went westbound, so it backed out, it headed west, made the loop to get out to Biddle, and continued north.
Okay. All right, thank you. And so, Mr. Martel?
Just very limited, Judge. I did witness the young man when I came in this morning, sitting with Mr. Connelly, who also I represent. I do know that I can attest that Mr. Connelly and Mr. Robinson met while incarcerated on the, while at the podium earlier, and as well as on the way out. I advised Mr. Robinson, you cannot drive. Mr. Robinson, when I came all the way out, was speaking with Mr. Connelly, and then Mr. Connelly I asked him, are you taking an Uber? He said, I'm riding with Connelly. I said, okay, that's a good idea. Ultimately, Connelly got into that. When I got into my car, Connelly got into the passenger side of the vehicle, and then I seen the rear driver's side of the minivan open up. I then exited the parking lot in my vehicle. So I'm of good faith that this young man did ride out of here as a passenger. However, I cannot attest, after I left the parking lot. But when I left, the passenger side rear view of the sliding door was open. So, Judge, I'm certainly understand and appreciate this court has terms and conditions. I went over these terms and conditions with my client. I'm confident if Your Honor does allow him the opportunity, he will not violate these conditions of bond. Certainly not calling the fine officer disingenuous in his observations. But I don't think that Mr. Robinson was seen driving, nor do I believe in full candor that he did drive out of this out of the parking lot here today after being, advised by Your Honor as well as myself, Judge. So I would ask Your Honor to set aside any violation of bond at this time and allow him an opportunity to continue following terms and conditions, Judge. Thank you.
All right. So, Mr. Robinson, let this be evidence that this court that we are watching. It appeared as though you entered the driver's side. Mr. Gendron is here to testify under penalty of perjury and contempt of court on his own, if he is in fact lying to this court, that he drove his cousin, and the description that Officer Kuziak gave as far as who entered the passenger side would have been Mr. Connelly, based upon Mr. Connelly's presentation here in court earlier with Mr. Martel, and that you entered on the driver's side. And based upon the direction of the vehicle and that Officer Kuziak wasn't able to see that Mr. Gendron was driving the vehicle, the court does, find that Officer Kuziak was not disingenuous in what he stated, because that is what he saw, and he was unaware that there was another individual in the vehicle. That is why I had you come back, because it appeared as though you drove out of this parking lot in direct violation of this court's order. When I told you this court, that we would be watching, sir, we were watching. That is why I had you come back to address this. I'm going to reiterate the bond conditions. I'm not finding there's a bond violation. I'm reiterating the bond conditions. No driving. If you didn't think that we were going to watch, we watch. And fortunately for you, you ended up getting a ride from Mr. Gendron. And he was kind enough to bring you back. And apparently kind enough to drop you back off. We'll see you back in 2 weeks. Not driving.
Thank you, Judge.
Thank you. Thank
Have
you.
a great day, Judge.
You as well. All right, we're on the record the matter of the City of Riverview versus Robert Walker IV, 23301.
Your Honor, good morning. Richard P. Serrano, P3328, appearing on behalf with my client. And Your Honor, this is the date and time set for his sentencing. Please state your name, please.
Robert Joseph Walker.
All right, good morning, Mr. Walker. I know you've been here for a bit, so I know that that you've been here this morning, and you're dressed very warmly, so I think that you rode your bike, right?
Sorry about my attire, yes, ma'am.
You're okay. I know that's how you get around. All right, so today's the date scheduled for sentencing on your client's plea to an amended charge of attempted telecommunication improper use. This is actually a resentencing because your client was originally sentenced in the treatment court, but for certain reasons, your client wasn't able to continue with the program. He was doing well in the program, but he wasn't able to get everywhere he needed to be based upon his extremely limited transportation options. Would that be accurate, Mr. Walker?
Pretty much, and more due to my health and getting around on the bike, but yes.
Right, because I believe you were having some significant health issues and you couldn't even ride your bike at that point.
Yes.
Yes. So, the recommendation council, or as to the PSI, are there any recommendations? Or are there any corrections that need to be made?
Your Honor, there is one in addition. My client, I'm pleased to report, now stays in Riverview, so he's no longer homeless.
Very
He
good.
does it himself. He has contact with his 14-year-old daughter who resides with the child's grandmother. And Your Honor, my client, he's been here before. The court is aware of that. He always appears timely. He rode his bike here from his location. And Your Honor, we would hope the court would adopt the recommendations. And he does have one matter pending. When is that, next month, you said, sir?
No, it's this month.
It's this month, on the 18th. And is that for another sentencing date?
Yes.
All right.
You do? Well, why didn't we just put them together?
I don't know.
I don't know, Your Honor. I know I've been representing him on a number of things.
It's a different attorney for that one.
Oh, okay, maybe that's fine.
Okay, can you pull up the other one for me, Ally, please?
I do recall when we were here, that someone else did represent Mr. Walker on his most recent case.
You were here.
Pardon me?
You were here.
Yeah, I remember you being here.
From 2023. It was in February of 23, and it's discoed and everything is just fine.
Wait, is that this one?
Yeah, that's not it. It happened in, I believe, July of this year. I was already sentenced. I mean, not
Oh,
sentenced.
yes, okay, yeah. So, it was August of this year. And got reduced to disorderly. And says sentences in 19.
Well,
If I may ask, who's the attorney of record?
It is Mr. DeWolf.
do you want to just do them both today? I can't imagine there's anything different for that sentencing than what we're already doing today.
The only other thing I would add, Your Honor, is that Mr. DeBlois is going to be here on the 19th according to my calendar. We have no objection to be sentenced today. Do you, sir?
No.
Okay, well then, let's pull that file and we'll recall this matter, okay?
If the pre-sentence report is available, Your Honor?
I don't need one, I have one for this one, it's
Oh.
going to be the same thing.
Okay. No changes since you reported with that one?
No.
Okay, we want to make sure, Your Honor.
Yeah, I mean, this is an amended one,
We're satisfied. What would you like us to do now, Your Honor?
have a seat,
Okay,
please. And then we will recall this one,
thank you.
okay? Gordon, can you ask permission for Mr. Walker's,
In the hallway.
current one, please? Okay, or that one, please.
A few minutes later.
Okay, and so thank you so very much. We are recalling the matter of Robert Walker, 23301, and we're also adding 241260. And counsel?
Your Honor, could I have that case number one more time, please? The most recent.
241260.
Thank you. Once again, Your Honor, Richard T. Serrano appearing on behalf of Mr. Walker, present for sentencing now on two matters, Your Honor. And I've already allocated on his behalf, Your Honor. We hope the court would adopt the recommendation that I viewed and whatever other remedy or sentence that the court fashions in the best interest of society and my client, Your Honor, that he is trying real hard to get through every day, really. And now that he's back home, we're hoping that he can be a little more safe. Is that all accurate, sir? Speak up.
Yes.
Yes, so after all that whole exercise, I didn't realize that the original charge was larceny because I don't have that information in front of me. So I have to give the victim an opportunity to be present at the sentencing date. So you are going to have to come back on the other matter. I was trying to get it all so you didn't have to worry about coming back, sir.
Okay.
But I was unaware at the time when I suggested we combine the sentencings, that there was a victim on the second matter. And so per the Crime Victims' Rights Act, I have to give that victim an opportunity to address the court.
Your Honor.
Because also it states that there is restitution to be determined. I don't have that information yet. It's set out for a couple weeks, and so I don't know that probation has received that information yet either.
Okay.
Your Honor, could I make a suggestion? I'm here on the 19th anyway on another case that the court assigned me to be back.
18th,
Your sentencing is the 18th?
I believe.
Is it, Your Honor?
I don't know, it doesn't show that in the file here.
I'm almost positive it's the 18th.
Ally, I think the Ally stated it was on the 19th.
I thought I heard that as
Let me
well.
double check.
Okay,
And if Mr. DeBlois was the attorney of record, then he's gonna be here on the 19th.
Yeah, it says sentencing 12/19 and then.
My day was wrong.
well, you would have been early and not late, so that would have been good.
So I'll leave it at the discretion of the court, Your Honor. We can adjourn all of the sentencings until the 19th. Mr. DeBlois will be here for the one and I'll be here for the other, or however the court wants to proceed.
Well, let's do that. Let's adjourn it so it's all on one, and so that way we're just kind of streamlining all of this, okay? I just think that makes the most sense for all of it. I can't move the one for the 19th up to today, like I said, there is a victim. And so we will, move this one over.
Your Honor, the only request I have is that the court allows me to come back at 2 p.m. on the 19th. Can it still be the sentencing for
Yes.
Mr. Walker? Okay. Because I have conflict at another court.
Right, Southfield, right?
Correct.
So does that mean my court day the time will be changed to 2 p.m.?
Yes, and so what we'll do is, I'll have probation coordinate and, communicate, and I'm going to presume that Mr. Serrano will just represent me for both matters.
Okay.
sentencing for both matters, but there will be communication with Mr. DeBloy from the probation department to see if there's any, issue with that.
Okay, so be
Okay.
here at 2 p.m. on the 19th.
Yes.
Yes.
Very good. Thank you, Your Honor.
You are welcome. Bond and conditions are continued.
Mr. Walker, good luck. I'll see you then.
Thank you, Your Honor.
Okay, thank you. We are going on the record in the matter of the City of Wyandotte versus David Martin, 241735 and 241212. So, Mr. Martin, your name for the record, please.
David Martin.
Okay. So, a couple things. Number one, it's my understanding that you want to represent yourself. However,
Can I, on the first case, 24-1212, that one alone. The second one, I will either represent myself or I will engage outside counsel.
okay. Sir, I'm going to start real quick. Do not interrupt, please.
Oh, I apologize. I apologize.
So the court is appointing an attorney to represent you for arraignment on both of these matters. You have not been arraigned on either of these matters. If you so choose to retain outside counsel after this arraignment date, you certainly may. But the court, based upon the allegations and the behavior that occurred yesterday, the court's not going to permit you to represent yourself today. So, Mr. Serrano, you did have an opportunity to speak to Mr. Martin, correct?
No, I have not spoken to him, Your Honor. I reviewed the file, but that was extended.
Oh, okay,
So I'm just gonna arraign him.
okay. So, counsel, your appearance for the record, please.
Your Honor, good afternoon, Richard T. Serrano, P33828. And today, Your Honor, I appear for arraignment purposes only. I understand, I reviewed the file that was in front of me, that was 241735, but I'd like a formal reading on the other one, 241212.
Okay. The court has before it on the 241735, the court has before an allegation that on December 4th, which was yesterday, at 2015 Biddle Avenue, which was here at the courthouse police department, that Mr. Martin did resist, obstruct an officer in discharge of his or her duties, and a reason to know was performing his or her duties. That's a misdemeanor charge. Maximum penalty upon conviction is not more than 90 days in jail and or a $500 fine. The complaint also alleges on the same date and time that Mr. Martin engaged in disorderly conduct. That's also a misdemeanor charge. Maximum penalty upon conviction, not more than 90 days in jail and or a $500 fine. Do you understand what your charges are, sir?
You're addressing me, Your Honor?
Yes, sir.
Yes, I do understand the charges. But may I respectfully ask the question?
Okay.
Don't, if I can make caution my client, Your Honor, don't talk about any of the facts of the case, sir, not what happened yesterday or any other time to do with your case, okay?
Procedural question.
Okay.
Go ahead.
My original arraignment date for 24-1212 was the day before Thanksgiving, and if you recall, the court experienced internet issues, so I was not able to be arraigned.
Correct.
But I did speak with Prosecutor Cayley, and he allowed me to waive my right to a public defender and represent myself.
Sir, I can understand that. However, this court has the ultimate authority to determine whether or not you have that ability to do so.
Okay.
And if the court feels it is in your best interest to have counsel appointed to you, that is this court's prerogative to see fit that there's an attorney to represent you. Based upon the actions of yesterday, this court finds it is in your best interest to have an attorney represent you for the arraignment purposes.
Gotcha.
You would make other arrangements after today's date, you certainly have that right, sir.
Your Honor,
I'm sorry?
Your Honor. Yeah, can I speak, Your Honor?
Okay,
I understood everything you said, so I understand.
okay. All right, and so, the court is entering, so on the 241212 matter, then the court's going to waive the formal reading. The court already, did the reading of the charges on the 241735. A not guilty plea will be entered on both of these matters. And we will set these matters for pretrial on December 11th.
8:45.
At 8:45 a.m.
May I respectfully ask a question, Your Honor?
Okay,
Do I need to write that down, or will I get something like a piece of paper telling me the date and time?
you will get something in writing. I'm going to fill this out here in just a few moments.
Okay.
And sir, you live in Ann Arbor?
I live in Southgate.
There was an Ann Arbor address in the file.
Right, sir, we have an Ann Arbor address for you.
May I speak, Your Honor? Your Honor, may I speak?
I have your new address here on the advice of rights from last week.
Your Honor, may I speak?
Yes, sir.
I received a summons for the arraignment on the 24-1212 at my current address at Southgate.
Yes, you must have your driver's license, your identification must indicate Ann Arbor.
Correct. Correct.
You make sure you're changing that, sir. How long have you resided in Southgate?
Since I of 2023.
Okay. And where do you work, sir?
I'm retired.
And from where are you retired?
Protective Life Insurance Company, Birmingham, Alabama.
Okay. And how long did you work there, sir?
I worked at Protective, which is my last company, about 10 years, from 2003 to almost the end of 2000.
I'm sorry, you broke up at the end. 2003 until what?
Until, let's say, 1/1/2013, so about 9 years.
Okay, and so then you've been retired since 2013?
Well, it's a bit complicated. I retired on a disability.
Okay,
So I was like 53 years old at the time, but I retired on a disability.
okay. And who do you reside with, sir, in Southgate?
Catch that, Your Honor.
I'm sorry?
Did not catch the question.
I didn't hear him, Your Honor.
Who do you reside with in Southgate?
Live alone.
All right, and sir, if you were to test today, what would be detected in your system?
I didn't hear the question, Your Honor.
If you were to test today, if I were to send you for testing, what would be detected in your system?
Are you asking if I was to be like BAC breathalyzer tested? Is that what you're asking?
If you were to be tested at a facility, sir, with a urine test or urine sample, what would be detected in your system?
There'd be no alcohol in my system.
All right. Have you ever failed to appear in court before, sir?
No. I mean, yesterday was an asterisk because I appeared, but I was late for my 9 o'clock date. But I informed the court and Prosecutor Kaylee in advance that I was running late.
Right. You informed the court that you were going to be about 15 minutes late, and it appears as though you got here about 3 hours late.
That is absolutely correct. Absolutely correct. I thought I would be able to get a ride, but I was not able to get a ride. So my only option was to walk the 4.5 hours from Southgate to here. And I apologize to the court for that. That was totally my fault.
Well, hold on, sir. Hold on. You're telling this court it took you 4.5 hours to walk from Southgate or from like Pennsylvania and Quarry area to the court?
No, Quarry in Pennsylvania to the court.
What's that?
From Quarry Road and Pennsylvania Road in Southgate to the courthouse.
Right, that's what I said.
Yeah, I'm a 65-year-old man. I'm a 65-year-old man, and it took me that long.
And you weren't able to call an Uber or a Lyft, sir?
I unfortunately am out of money for an Uber. Otherwise, that's exactly what I would have done. So I was trying to get a ride anyways, but I wasn't able to do that.
All right.
So again, I beg the court's forgiveness for my tardiness.
All right. Sir, you seem to have a significant issue with alcohol consumption. You have a charge, the charge from August is an alcohol-related offense. You have multiple alcohol-related offense matters from Johnson County Sheriff's Office. Is that Kansas or is that Alabama? Where is that?
Yeah, Johnson County, Kansas is a suburb of Kansas City, right?
Okay. Well, and I presumed it was Kansas because KS is in front of the arresting agency's phone number, so I presumed it was Kansas.
Yeah, you would be correct.
And I'm seeing a number of cases that are alcohol-related driving offenses. And you also have one out of the 22nd Circuit Court in Washtenaw County from 2018. And you also, what was the matter in 2014 out of Romulus? Was that also an alcohol-related driving offense?
All of those were DUIs. All of those were DUIs.
All right. And then apparently, there was some concern by the prosecuting attorney that you were under the influence yesterday. So here's what this court's going to do.
Your Honor, may I try and rebut what you said?
I recommend you do not explain anything about your level of intoxication or not yesterday.
I respectfully request, attorney, that I be allowed to respond to the judge's charges.
Well, I made a record, Your Honor.
Okay. Yeah.
During case 24-1212, I sent a lengthy email to Prosecutor Kaylee outlining my case and why the city of Wyandotte had no case and why I was not publicly intoxicated. So that's all outlined in an email to Prosecutor Kaylee.
Okay.
Regarding yesterday's arrest, for the 4.5-hour walk, I brought along a styrofoam cup with some vodka and OJ. I poured 3 half-ounce shots of 80 proof vodka into the cup along with some OJ and drank that along my walk. So it was a 4.5-hour walk, which meant that my body had 4.5 hours to metabolize three standard drinks. I was arrested, but I believe it was Officer Hunter accused me of being intoxicated, and I proceeded to very coherently and articulately spout off college sports trivia. And I convinced him that I was not drunk, and he told me so to my face. He said, "Okay, you were not drunk."
Sir,
Yes.
this is not the time that we're going to go into the back and forth regarding the facts of the case. Your attorneys advised you not to do that. Sir, clearly based upon your history, you may not feel as though you are drunk per se, but maybe some testing would suggest otherwise. But in any event, there is an alleged consumption of alcohol yesterday, as well as what your charges on the 1212 matter, as well as your significant criminal history regarding alcohol-related offenses. So what this court is going to do is this court is going to order on case number 241212, the court's going to order a $7,500 personal bond. Do not to possess or consume any alcohol or drugs that are not prescribed, and you are to have an alcohol tether through the Wayne County Jail.
So, can I speak, Your Honor?
Yes.
Can I speak?
Yes.
I am not able to come up with a $7,500 bond, so the alternatives are I will just have to be held incarcerated.
Sir, $7,500 personal bond, which means you don't have to post any money. But you are going to remain in custody. You're going to go down to the Wayne County Jail where they're going to affix you with an alcohol tether. One bit of consumption, sir, Wayne County will come out and arrest you. I want you to be very, very clear with that.
I'm not clear with what was something you said. You said I'm still in incarceration, but once the tether is affixed, will I be released?
Yes.
Okay.
But that will occur at the Wayne County Jail because that is going to be who monitors your tether. So they have to put that on you.
Okay. Will that happen today?
I don't know, sir. I would presume not, since it's 2:30 in the afternoon. And by the time you get down there, it will probably be somewhere between 4 and 5 o'clock tonight. So hopefully it will be tomorrow, but I can't guarantee. I don't know how many other tethers they need to, I don't know how many people are waiting for tethers.
Right.
So as it relates to 241735, the court's going to also order a $7,500 personal bond with the same condition, alcohol tether through Wayne County Jail, and not to possess or consume any alcohol or drugs that are not prescribed. This is for the safety of you ultimately, sir, as well as the public, and to make sure that you're complying with court conditions.
Your Honor, may I speak? Your Honor, may I speak?
Okay.
I beg your forgiveness. I just want to make sure I understand. The second case, the disorderly conduct case is not an alcohol related offense. Yet you still feel that I need the tether and the personal bond.
Sir, let me clarify. I just I set the same bond conditions for that case as I did for the 1212 case.
I didn't catch that, Your Honor. I didn't hear you.
All I did was I just mirrored the conditions.
Mirror the conditions.
Yes, they're the same conditions for both cases because they're going to be held on the same day.
All right.
All right, anything else?
I have nothing further, Your Honor.
All right, you'll get a copy of your bond condition sheet, sir, and then we'll see you back on Wednesday.
Thank you, Your Honor.
Thank you. Have a good day.
Have a good day, Judge.
You too.
Thank you.
Is that it? We're gonna call the warrant.
I'm ready.
All right.
Let me get my state stamp out here.
Okay.
Oh, yeah, we did the warrants.
All right. For those of you discerning old school court tube watchers, you will remember Judge McNally, the one, the only, Judge Dad. This guy has a style like no other judge. We haven't seen him for a real long time. He's made his reappearance this week after a very long hiatus. Let's dig into some classic Judge McNally, shall we?
Smith. Against Dantes, Anthony Smith, 243B1432738. Your name, sir?
Dantes Anthony Smith.
Good morning, Judge. Mazen Gaith, on behalf of Mr. Smith.
All right, so you worked this out. There's going to be a plea allowing an unlicensed driver to drive, right?
Correct.
Suspend to be dismissed, right?
Correct.
Is that what you want to do, Mr. Smith?
Yes, sir.
If you do that, the possible penalties are up to 500 fines, 90 days jail. Costs are all of those. 0 points. It won't be reported to the Secretary of State. Do you understand that?
Yes, sir.
And did you sign, read, and understand an advice of rights form here today?
Yes, sir.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes, Your Honor.
To the charge allowing unlicensed driver to drive, how do you plead?
Guilty.
Were you in control of a 2010 Chrysler that was being operated on Dix Toledo near Allen in Brownstown, April 17 of 23 at roughly 2:48 p.m.?
Yes, Your Honor.
And you were in control of that vehicle, suspended, knew it, and drove that vehicle. Is that true?
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Anybody forced you to plead guilty?
No.
Please accept it. Do you see how many warrants he's had?
We did see it.
They're all cleared up, Your Honor. I have the license right now.
Well, wait a minute. Now, come on. You're telling me you went over to Bloomfield Hills in the last 2 weeks? I mean, I can run it again if you want. Bloomfield Hills the last 2 weeks, 2 cases there, Oak Park, Taylor. Which of those courts did you go to?
All of them, Your Honor.
You've been to all those courts?
Yes, Your Honor.
Currently, Judge, Mr. Smith does have a valid license, Judge, so.
Okay. Well, that's good. You finally are growing up, huh? Anything?
Judge, we just like the court to adopt the plea agreement. Mr. Smith does understand that he needs to keep his license current and that he needs to take care of any outstanding holds that he does have remaining, but he understands what he did is wrong, and this is going to be a one-off, correct, sir?
Yes, sir.
Where do you work at again?
Davenport Construction, so based out of Belleville.
Anything you'd like to say?
Pretty much, I apologize for, being behind the wheel of a car, while I was suspended.
All right, show up in court from now on, will you please?
Yes, sir.
100 fines, 125 costs, 75 victims' rights fee, $50 justice assessment, 40 in attorney fees. The total's $390 or 60 days. You can pay that today?
Yes, Your Honor.
Okay, go down the hall, take care of that. Good luck. Again, you just make matters worse if you don't show up. If you get a ticket, show up, talk to me. All right, good luck. Ballard Jackson, Michelle Shanique Ballard Jackson. This is file 24B144935, 24B145081.
Good morning, Judge. Mazen Gaith, on behalf of Ms. Ballard Jackson.
Ma'am, your name?
Michelle Shanique Ballard.
So as I understand, she's going to plead on 935, which is assigned to me. And if she does that, she's going to have the other case, prosecutor's going to dismiss the other case assigned to me, which is 081.
Correct.
Prosecutor's going to dismiss that, right?
Correct.
Is that what you want to do, ma'am?
Yes, sir.
If you plead guilty to driving on a suspended, I'll dismiss the other charge. The possible penalties are up to $500 in fines, 93 days jail costs, or all of those in 2 points. Do you understand that, ma'am?
Yes,
And did you sign, read, and understand the advice of rights?
yes,
If you plead guilty, you'll be giving up all those rights. There will not be a hearing or a trial. Do you understand that?
yes,
To the charge driving on a suspended, how do you plead?
yes,
On February 7 of 24, were you operating a motor vehicle in the township of Brownstown on Sibley near Inkster at 3:57 in the morning?
yes,
Was your license suspended
yes,
or revoked? Which was it?
suspended,
Why was it suspended? Unpaid tickets?
yes,
Are you on probation or parole?
no,
Anybody force you to plead guilty?
no,
All right, I'll accept your plea. I'm going to go ahead and dismiss the other charge pursuant to agreement that you reached with the prosecutor. That's on 081. That's an offense date of February 6 of 24. This case I accepted your plea on is from February 7 of 24. Counsel, you ready?
Yes.
Anything?
Judge, we'd ask the court to adopt the plea agreement. Ms. Jackson understands that she needs to get her license in order, and she's in the process of taking care of.
Did you
And
ever?
outstanding home.
She never got licensed?
no, I've never obtained one.
Why didn't you go and get licensed?
I got an appointment on 11.
She's
I
in the
was
process.
paying off all of my tickets and you guys were the last ones I had to pay. Cause I had warrants, so they wouldn't
I
give me.
get it. You're 39 years old and you've never bothered to go get a license?
People were driving me around and then I started driving and it
I'm
was,
just telling you, you've been driving around when you shouldn't be driving around. This has got to stop. Okay?
She understands that, Judge. She's in the process of taking care of all that.
Anything else?
no, sir.
100 fines, 210 costs, $75 victim's rights fee, $50 justice assessment, $40 in attorney fees. So totals $475 or 90 days. Can you pay that today, ma'am?
I can do it in 90 days. I work in manufacturing and we were laid off. We're just getting back.
Listen,
I'm gonna be honest, I can't do it today. I can do,
well, I know you can't do it today. You wouldn't have told me you can do it in 90 days if you could do it today. My difficulty is you got 2 tickets, one day after the other. You got one on February 6th, you got one on February 7th, and you never bothered to appear here until November 22. Now, I have to tell you, I don't understand this. I mean, there's nothing about any of this nonsensical garbage that's going on with people not showing up and not respecting courts. Nothing about it I understand. I mean, I must really be getting old. And then you come in here and you don't have any money and you want me to be nice and give you 90 days to pay. Where were you? I'd have given you 120 days if you'd have come here back in February. But now you've had 9 months to save money. You haven't done anything. But I'm going to be a lot more fair with you than you've been with us. Are you okay with that?
yes,
Are you sure?
yes.
Okay, good. Because if I wasn't going to be as fair or more fair with you than you've been with us, then probably be going back in that room there. How much can you pay today or by the end of the week or next week? I'm going to set you up on a weekly or bi-weekly plan. You're still working, right?
Yes,
You're making decent money.
our hours just picked back up.
How much can you pay anything by the end of next week?
I get paid on the 11th. I can.
How much can you pay on the 12th?
$100.
Are you sure?
Yes,
I'll tell you what. Today is the 11th, 12th. You pay 100 by December 13th. You get paid bi-weekly?
yes,
How much? And then I'll let you pay 75 bi-weekly if you think you can do that, starting on December the 27th. Does that sound good?
yes, sir.
All right, that's what I'm gonna do. And then every week, every 2 weeks, you pay $75. Okay?
Yes,
Now, if you don't have the money, you're gonna just show a little bit of courtesy and respect, and you're gonna call the court and say, hey, can I come in and talk to Judge McNally at 8:30? Or you can just walk in here on or before your due date, or If it's more convenient, I don't even mind doing it by Zoom, but you cannot ignore courts like this. Okay?
Yes,
Fair?
yes.
What city do you live in?
I live in Dearborn.
Okay, so it might be easier for you to Zoom if you know how to Zoom, okay?
Okay.
Wish you well, stop doing that. And by the way, I am dismissing 5081 pursuant to the agreement. So for a dismissal. Good luck. Merry Christmas to you, ma'am.
Thank you.
Need
Thank
more
you.
time, call me.
Okay.
Call the court. We'll go on Zoom. Jonathan Michael Comby, 24B147046.
Good morning, Judge. Mazen gave appearing back, Mr. Convey.
What?
Judge, we're asking for an adjournment on this matter for at least 30 days. The new plea agreement or the plea sheet should be in the file, Judge.
Yeah, it just says, okay, so defendant requests adjournment, right? That's what you guys want?
We're asking for an adjournment. Mr. Comby wants to have the sample tested through a private lab, so we're asking just for enough time to have that done and then get the results.
What was the, your appearance?
Caitlin Foley Carr, in Brownstown Township.
I'm just curious, what was the, oh, this was a controlled substance, right? He was,
Correct. It was cocaine and Suboxone, Your Honor.
okay. All right, we're gonna adjourn it. I guess we have to take it to January the 15th, right, Lisa?
Yes, 9 o'clock.
Okay, at 9 o'clock. Sir, if you want a lawyer going forward, you have to fill out a petition for one. And then I'll look at the petition, make sure you're indigent. If you are, I will appoint you a lawyer, okay?
Yes, Your Honor.
So you can do that right there if you want to, and then you're gonna have to go down and get your notice.
Okay.
Any questions?
No, Your Honor.
Anything else, Ms. Gay?
Nothing else, Judge. Thank
Ms.
you.
Foley Carter?
Nothing, Your Honor.
Have a good day, you guys.
Thank
Thanks.
you, Judge.
Thank you.
You want to fill out a petition?
Selena Rodriguez. Selena Celeste Rodriguez. I need Mr. Baldwin in here. Is Kelton Brochet here?
He's on Zoom now.
Why don't you bring in Brochet too, Lisa, please? Give me 1 second, ma'am, okay? And then there should be the lawyers on Camilla Barkovic and Mr. Bologna on that one case. Posac. All right, come on up, Mr. Baldwin. I need your appearance, please.
Absolutely.
All right, this is people against Selena Celeste Rodriguez, 242-643-9248. Your name again, ma'am?
Selena Celeste
Attorney Mike
Rodriguez.
Baldwin, I'm sorry to overtalk. Attorney Mike Baldwin, House Counsel for Ms. Rodriguez. Judge, just please bear with me while I check my notes. Yes, Your Honor, she's had 2 adjournments. I do believe that you're not on a payment plan, are you? Oh, you are. Okay.
Not on what?
She's on a payment plan with another jurisdiction, but she has not been able to clear that ticket. So she's going to plead guilty as charged to A, and B will be dismissed.
Mr. Brochet, mute yourself, sir. Mr. Brochet, mute yourself. Is that what you want to do?
Unmuted.
If you plead guilty to suspended driving on a suspended, I'm going to go ahead and dismiss the no insurance. The possible penalties are up to 500 fines, 93 days jail costs. So all those 2 points, do you understand that?
Yes.
Did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes.
To the charge driving on a suspended, how do you plead?
Guilty.
Were you operating a motor vehicle on Fort near West in Trenton, October 18 at 10:51 p.m.?
Guilty.
Were you operating a motor vehicle on that date at that time in the city of Trenton?
Yeah.
At that location?
Yes.
Was your license suspended?
Yes.
Is it still suspended?
Yes.
Are you on probation or parole?
No.
Anybody force you to plead guilty?
No.
Please accept it. The insurance charge is dismissed and the please accept it to suspend. She doesn't have a bad record. She just didn't take care of this one case. It looks
In
like.
Wyandotte, correct, Your Honor, and she has paid just over.
Why not? I think it's 36, doesn't it?
Was it 36? And oh, it was
Detroit.
Yeah, I have
Oh.
one in Detroit. That's a ticket. The suspended license was in Trenton.
Okay, Your Honor.
No, I know, but you have to go take care of the no proof
Yeah,
to get that suspension lifted, right?
yes.
She's already made 100 and something. She just owes just under 100. Judge, she's a self-employed, I'm just gonna say she's in the cosmetology field, cosmetics. She has a significant other who provides a substantial amount of their income. I'm gonna ask for fines and costs in this case, Judge. I'm gonna ask that maybe you consider going a little light.
You always can ask me to go light.
I do.
It's all right.
It's Christmas, Judge. So she's making a payment there in at the 36th district.
I got it. She doesn't have a bad record. I'll do the best I can, okay? I mean, it's still suspended though, but what would you like to say? Anything?
No, I'm just gonna try to pay off the ticket for Detroit.
100 fines, 50 costs, 75 victims' rights, $50 justice assessment. Those are mandatory. Attorney fees are 40. Totals 315 or 60 days. You probably need time. Do you need
She
time?
pay 100 today. Is that correct?
Yes.
100 now. I'll just let you pay 25 per week, starting January 3rd. You got kids, ma'am?
No.
Okay. Well, then you can start paying. No, I'm just kidding. January 3rd. If you don't have the money, come talk to me, please. I don't know why people don't do that.
Okay,
I'll
thank
be
you,
glad
Your
to give
Honor.
you an extension on or before the due date. Are you with me?
Yes.
And we talked about that, Judge. She has a clear understanding.
Good enough. Colton Elzy, good luck, ma'am.
Thank you.
Colton Elzy or Brochu, 23T640-673. Mr. Brochu, state your name.
Colton Brochet.
Attorney Mike Baldwin, House Counsel for Mr. Brochet.
So I keep trying to get reports on your progress.
Your Honor, I have an explanation. He's reached out to Bruce Marks. He did his part as soon as Your Honor had instructed him at the last court matter. He's followed up with him several times. Mr. Marks is jammed up. That's at the Christian Guidance Center. We are waiting on Mr. Marks to provide that information.
Wait a minute. You mean to tell me? Go ahead. Go ahead.
But Mr. Brochure has done his part to reach out. Mr. Marks is backed up.
He's that backed up? I mean, I've been asking.
Backed up. He said he had numerous, several. Brochure.
I adjourned the sentencing 5 weeks to see so you can get documentation as to how let me just read my notes. September 12th. I said, you're going to go into sober living and an IOP program. Defendant to get paperwork regarding how he's progressing. It says, I think, I could be wrong. Sometimes I can't read my own writing, but yeah, no, it's at Christian Guidance Center.
Correct.
Then on October 10th, he's here. Adjourned sentence 5 weeks. Defendant to see how he's progressing. And I asked him to get paperwork. This is December. The guy is that busy, he can't get us something for 2 months?
Maybe a show cause, Your Honor, for Bruce Marks to come in and explain why he cannot provide this information.
How many times have you tried to get a hold of him? Some of these people, you just got to stay on.
He did.
I call him once or twice a week. He always takes off Thursday and Fridays. I've been in front of him before when I've been in that treatment center. So I feel like there's nothing I can really do. I've been trying to get a hold of him. I am in a new sober living home. I switched from the last one I'm in, and this one's more structured and it's in a better location.
When did you get there?
I got there about the day before Thanksgiving. I now have 2 month clean time under my belt. I'm trying to talk to
a month.
3 times. I've been here for 2 months. The sober kind of 2 months sobriety.
I don't understand why it's so difficult to get. I'd like to at some point get rid of this case, but I'm not going to do it. I'm not going to do it unless I have some reports.
Right. I can call him immediately.
Slow down a second. Slow down.
Sorry.
So he only works Monday, Tuesday, Wednesday, or does he work on weekends too?
He never works on weekends. I've been in the Christian Guidance Center a couple times, and he's always gone Thursday and Friday because he likes to take 4 days.
Nice. Well, love this country. So we have somebody, I don't know what to tell you. I need some proof.
Yes, sir.
Why are you here again?
Shimke, my phone's in the office. Shimke's covering for me on the 19th. I'll be at the circuit court.
Lisa, I hate to do this. One more adjournment, okay? Adjourn to December 19th. Call them up. Tell them, why don't you write them an email?
Yep,
Say, hey,
that
Judge McNally's been asking for this information. If
Okay,
you're
that's
not
a
going
good
to provide
idea.
it, let us know.
Yep, I will talk to my recovery coach, and him and I will start reaching out again.
Big
I
time,
really
like every day. Obviously, he's not making this on the top of his priority list. It's not like you just called him on Tuesday and said, I need it for Thursday.
Yes, sir.
December 19th, what time, Jen or Lisa?
8:30.
8:30.
Okay, and is the meeting ID the same?
Yes.
Thank you, sir.
It's the same. Have a good day. Good luck to you.
All right, thank you, Mr. McNally. Have a great day. Enjoy your holiday.
Thank you. You too. We'll see you before then.
Yes, sir.
Sandra Kia Forson, 24U 559-220 A and B. And then we're going to do Ms. Schmidlin.
Yes.
So I'm going to need you guys to call Beth in here on Schmidlin. Pardon?
Did you do Kyle Houston? He was in the courtroom.
I think I did.
I'll see if I can.
I think I already called that. How you doing?
I am great. How about yourself?
Your name?
Sandria Nakia Forson.
So you got improper lights and obstructed vision.
Yes, sir.
What do you want to do?
I did correct it, so I replaced the lights.
Listen, I'm just playing around.
I
The officer
replaced
didn't, the officer didn't show up. I'm dismissing your case,
Okay,
okay? Have a good day.
Same
Please,
to you, sir.
please be careful. What was the obstructed vision for? Tinted windows?
Yes, I corrected that.
Did you?
Yes,
All
I got
right.
receipts.
Merry Christmas.
Thank you.
Case is dismissed. We gave the officer 15 minutes. He didn't show.
Thank you.
Was it not? Ms. Schmidlin, who's your lawyer again?
Mr. Baldwin.
Mr. Baldwin.
Why'd he walk out?
I don't know what he wants, so.
I don't either.
Judge, you sent him to get Hudson, but you already did that one.
I thought so.
Yeah.
I thought I did Hudson. Oh,
He wasn't
yeah,
in here.
because he
Did
was
it
the
without
one,
him.
he wasn't in here. Right. Can you see if Mr. Baldwin's there? I know who Mr.
There he
Tell me.
is. There he is.
Yeah, People Against Christina Marie Schmidlin, 23F239-299A. Mr. Baldwin, I knew you were tied up. There was nothing to do but adjourn it. I already called Houston.
Okay,
That's
thank
right.
you,
I called
Judge.
him.
Thank you
Ms.
very much.
Schmidlin, your name?
If I may, because I have to provide notes to MIDC, is that adjourned to Houston?
I think the 19th.
Thank you, Judge.
I try not to do that, but I
No,
didn't
no,
want
it's
to make him
okay.
keep waiting. I know you're busy.
I get it. He had a child out there too, a baby.
Your appearance?
Attorney Mike Baldwin, House Counsel.
Ms. Schmidlin, your name?
Christina Marie Schmidlin.
Ms. Wiles?
Elizabeth Ross, patient owner.
So what is she going to do on this?
She's going to plead guilty, Your Honor.
All right. If you plead guilty, this is your 6th technical violation.
Yes, Your Honor.
You could be incarcerated on this for the maximum. I'm not saying I'm going to do that, but it is 93 days. Do you understand that?
Yes, Your
Did you
Honor.
sign, read, and understand the advice of rights?
I guess I have.
If you
Your
plead
Honor.
guilty, you'll be giving up all those rights and there will not be a hearing. Do you understand that?
Yes, I do, Your Honor.
All right. To the charge, you failed to refrain from, failed to submit to testing on December 2nd. How do you plead?
I plead guilty.
Did you fail to submit to testing that day?
Yes, I did fail.
Anybody forced you to plead guilty?
No, they haven't.
Ms. Wiles, you had sent me an email saying she was going the next day. Please tell me that was negative.
Christina went in.
On the 3rd, right?
The 29th, the 3rd, all of her testing has been negative, and including December the 3rd, which was that Tuesday.
Why did she miss?
She's not prioritizing life activities, and I went through this with her and explained that she needs to prioritize and make sure that court orders are on the top of her prioritization list, because, you know, if you don't want to.
Christina, come on.
Well, I think, did that help you when I talked to you about that?
Yes.
Well,
Okay,
this
I
is
think
her.
she's not starting to understand.
She's understood this. She's been in
Well,
the
I know,
sobriety
but
court for.
she's not putting this up on the top.
Well, she should be.
Oh,
If I've been that, what?
We have that clear understanding now that she's had, I saw the register of actions. There was 3 violations in a row there. So on the register of action, so.
I'm not understanding why you weren't there yet. Why didn't you go?
Your Honor, I completely forgot to call. It was a busy morning at work. I was pulled aside. I was reprimanded. When I came back from rehab, I came back to somebody that was trained for my position. I was warned. I ran out of the office on Friday, tried to, do chemical testing. I failed, to even call.
What do you think? I'm accepting your plea. I'm gonna sentence her now, but this is the 6th violation.
Yeah, Your Honor, I actually met with Christina yesterday. I went over kind of, what it looks like, the fact that we don't do a lot of back-to-back testing. She tested the first, then the miss on the second. The fact that it's after holidays, we're coming off about 3 months since her last positive. I told her how it's going to affect her sobriety days because she was technically supposed to phase up after that previous violation next week. So we talked about all of it, but to her credit, on the other positives, Christina was never really forthcoming in regards to any of the violations before. I think she's being forthcoming here. She did all the right things. She responded to me. I do know that she struggled testing on the 29th. She's got now an issue at work because of that, which was 2 days after the holiday. All positive things from her therapist, Alex, that I do think it's a responsibility thing. I don't think I disagree with counsel and in speaking with Christina yesterday, but this is a bigger burn for her because we're at that position where it's going to affect documented days. And again, coming off a holiday, all of that really kind of hurts a little bit.
So what do you think? What do you think?
Well, definitely phase extension is going to be required as far as the 90 days documented sobriety. She's well within the capabilities of still being able to benefit from phase 4 if there's no other violations and her ability to still.
So phase extension we need to do.
Phase 3. And I would believe at this point, any hours of community service would be beneficial. I know that she's done a work program, but again, I'm trying to think employment. She did take a hit. It was something we talked about in regards to work when she went inpatient, and I think some hours of community service.
I'm fine with that, but I've got to extend her now until phase 2, until what day would we be?
Her 90 days would have been December 6th.
Right.
So we got to go out to at least March 6th at this point.
Gosh. It's not good.
Your Honor, she does want to continue on the more difficult path of being on probation in pursuit of her sobriety. She doesn't want to take the easy out, ask for a revocation and some county time. So I commend her for that. She wants to continue on, and she's embracing her sobriety as part of this.
Anything else?
She'd like to apologize, Judge. I think the reality of prioritization with court orders came to light today afterwards.
But I think she's understood we're serious.
I don't think she realized that at some point you can go to jail. I don't think she realized how close, I just don't think the public realizes how close that they come to jail sometimes.
I've never sent you to jail yet.
No, rehab.
I know, but shame on me. 10 hours community service. You have until January the 15th to complete those. I'm gonna extend phase 2 until March 6th. I don't know what else to tell you. I feel like sometimes you seem so compliant, and others you seem like you're fighting us. And I don't know how to put it other than that. I sure don't want to see you lose your job. I don't want to see that happen, but you got to be careful with this stuff, okay?
Yes, I
All right.
appreciate all your help, Your Honor.
All right, good luck. I'm not going to assess costs. I know you. Stay clean, please.
Yeah.
We got a tough month coming up here. Very, very significant amounts of temptation. Okay, good luck.
Thank you, Your Honor.
Thank you.
Thanks. You guys ready on this?
We are, Your Honor.
Is Ms. Barkovic's client in there with her?
I do not know.
Yeah, they're both on Zoom.
All right, let's go. Where's the file on that, counsel? Against Justin Joseph Posac, 24T6427508, B and C. Your appearance?
Anthony Bologna, I'm about the city of Trenton, Your Honor.
And good morning, Your Honor. I'm sorry.
Go ahead. No, you're
Camilla.
fine. I just wanted to make, good.
I keep cutting you off.
No, I'm cutting you off. My mistake. I apologize. Go ahead. My apologies.
Thank you, Judge. Camilla Barkovic appearing on behalf of Mr. Posac, who is present.
Okay. So you guys want to argue. Mr. Posac, your name?
Justin Posac.
Okay. There's no resolution. We're going to proceed with the motion, correct?
It's my understanding that the defense wants to proceed with the motion. Your
Okay,
Honor.
go ahead.
Judge, I will rely on my written motion. I do acknowledge receipt of the people's response. My argument is very simple, and that is the people cannot admit the defendant's own statement and independent proof that he in fact operated the subject motor vehicle while intoxicated on the date in question. There were no independent witnesses interviewed by law enforcement in connection with this case. There is not a single witness based on my review of the discovery that observed the incident occur and provided a statement to law enforcement identifying Mr. Posac as the individual that was driving the subject vehicle at the time it crashed. And that is the independent evidence that they need. In the people's response, they argue, well, the defendant's wife made statements indicating that he had been drinking and was operating the vehicle and was involved in the accident. But a review of the discovery establishes that his wife was not present on scene at the time the alleged incident occurred, if ever, and she has no personal knowledge as to what, if anything, may have occurred. Furthermore, her statements are hearsay. So in summary, my position is that people do not have sufficient independent admissible evidence to establish that the defendant committed the crime of operating while intoxicated. And thus,
And you also have
I'm
privilege.
asking
You
that-
also have privilege issues. But here's one thing I have to bring up to you, because I'm going to invite you to tell me where I didn't read this appropriately. When you guys came in here for the hearing, you both agreed, and I thought we were going to go with an actual evidentiary hearing. You both agreed to stipulate to the facts contained in the police report. Is my recollection accurate?
It's accurate, Your Honor.
Judge,
You
we
agree with
also
that?
stipulated to the body worn camera recordings.
Well, nobody's mentioned the body cam recordings, and I never saw the body cam recordings. And was I supposed to get the body cam recordings? I don't remember anything about body cam recordings. Somebody needed to give those to me so I could look at them. Is that true? Did you guys agree to that?
Yes, we did agree that body cam would be stipulated to as well.
Well, I know, but I'm supposed to make a decision. I've never seen the body worn camera.
I understand. It's defense's motion, Your Honor, so they're in possession of them.
Well, what's that going to show me, Ms. Barkovic?
Exactly what I just
Just give you the
indicated
adjournment so you don't
on
have
the
to wait
record
around. Is that all
in
right?
support of my argument that no independent witnesses identify the defendant.
Okay, but
as-
here's what I'm getting at. You wrote in your motion here, multiple law enforcement officers responded to the relevant location based on the dispatch. The responding law enforcement officers observed several individuals congregated on the side of the roadway upon arrival. I didn't see anything with respect to the police report that indicated that. I didn't see one thing. I saw them. Posac officer said that he was there. Mr. I'm sorry, sir, is it Posac or one thing? I saw them, the officer said.
Okay. Crazy audio stuff happening. I'm not sure why. So, with that happening, I'm going to do this.
Just give you the adjournment so you don't have to wait around. Three wheels, the right.
Your Honor, is if there's independent circumstances, which there are here, there's independent facts besides the admission. The corpus delicti is if he was just sitting there and he makes
Driving, such as having the keys in his hand.
In any other case where a patrol officer receives a call from dispatch.
Yes.
Well, I know, but contained in the police report is my
Admissible evidence to establish that the defendant committed the crime of operating while intoxicated. And thus,
and you also have
I'm
privilege.
asking
You
that-
also have privilege
There we go.
issues. But here's one thing I have to bring up to you because
Lying by the skin of our teeth,
tell
people.
me where I didn't read this appropriately. When you guys came in here for the hearing, you both agreed, and I thought we were going to go with an actual evidentiary hearing. You both agreed to stipulate to the facts contained in the police report. Is my recollection accurate?
It's accurate, Your Honor.
Judge,
You
we
agree with
also
that?
stipulated to the body worn camera recordings.
Well, nobody's mentioned the body cam recordings, and I never saw the body cam recordings. And was I supposed to get the body cam recordings? I don't remember anything about body cam recordings. Somebody needed to give those to me so I could look at them. Is that true? Did you guys agree to that?
Yes, we did agree that body cam would be stipulated to as well.
Well, I know, but I'm supposed to make a decision. I've never seen the body worn camera.
I understand. It's defense's motion, Your Honor, so they're in possession of them.
Well, what's that going to show me, Ms. Barkovic?
Exactly what I just indicated on the record in support of my argument that no independent witnesses identify the defendant.
Okay, but here's what I'm getting at. You wrote in your motion here. Multiple law enforcement officers responded to the relevant location based on the dispatch. The responding law enforcement officers observed several individuals congregated on the side of the roadway upon arrival. I didn't see anything with respect to the police report that indicated that. I didn't see one thing. I saw them, the officer said that he was there, Mr. I'm sorry, sir. Is it Posac or?
Oh, it's Posac. Apologize, Your Honor.
Posac. I'm sorry. Mr. Posac was there, and his what was later to be determined his wife, Mrs. Sam. But I didn't see one thing where any police report or anything else that's been presented could tell me or show me that there were several individuals congregated on the side of the roadway when the police arrived.
Your Honor, that is because it's not identified in the police report, and that is why I also sought and obtained a stipulation for the court to review the recordings. I obtained that from a body-worn camera recording. And I understand, I'm sorry if there was some miscommunication. I'd be happy to submit that recording to you. I do think it's absolutely crucial as it relates to the motion.
This is why I always feel we're better doing an evidentiary hearing, because this, were there other individuals seated there or by there at the time of this? Do you concur in that?
Yes, but if I may respond to the motion and the arguments, while it's a very creative argument and motion, the fact in the case law which we've cited is that if there's other circumstances which lead the officer to believe, which there are in this case, and there are in the police report itself, the bloodshot eyes, the smell of alcohol, that is sufficient to establish an independent basis for the officer to proceed. And that's what happened here. So it's not just the admission alone, it was these other circumstances involved, which the officer relied upon. So even if you were to strip the statement of the wife, which is the wife saying that he drove the car and was in an accident.
I think there's privilege issues involved.
But
there,
arguably
too.
she waived it.
Nobody's
because-
mentioned that.
Well,
but
arguably there's a waiver, but let's set that aside. If you look at just the bloodshot eyes, the smell of alcohol, that's enough for the officer to proceed independently at that time.
And Judge, with respect to that, my argument isn't whether or not the officer had enough to proceed. This is more of a motion in limine where I'm arguing that under the corpus delicti rule, the evidence is not admissible in court absent sufficient admissible proof that he committed this offense. And intoxication is.
Let me ask you a question. I want to ask you a question. Come on, please. No, I don't need to jump up. Let me ask you a question. Your argument seems to be, yeah, well, there was enough about what is the difference between this case and any other case where a patrol officer receives a call from dispatch and says that there's been an accident in a certain area. And the officer goes over there, and the first thing he does or is going to do is going to ask any individual who's in the area, were you driving the car? I mean, if there's no independent witness, you're basically telling me, are you not, that they could not get by the corpus delicti rule because they don't have independent proof, no eyewitness that anybody watched this defendant driving the vehicle.
So, Judge, I will tell you what the difference is. I didn't represent all of those other people you're talking about, okay? I acknowledge that this is a creative argument, and it is my interpretation of the law. And that's what I've set forth. But like, if you want to consider this case factually in comparison to other run-of-the-mill drunk driving cases, typically an officer will approach a vehicle and the defendant will be the only person on scene. The defendant will be seated in the vehicle. The defendant will have other indicia that he was in fact driving, such as having the keys in his hand or having an injury if an accident occurred. There's none of that here. My position is this is a scant factual scenario, and really what it comes down to is his own statement exclusively.
Was anybody else in this body worn cam spotted to be near Mr. Posac?
Yes, Judge.
But seated there or in just in the general vicinity?
They were standing right next to him. This was like a residential area, so he was seated on the curb. His wife was seated next to him. There were several other individuals like on a grassy area next to them by the sidewalk.
What do you have to say?
I go back to the first argument, whereas, yes, it's a statement made by him, but that's not the basis of why the officer continued with the field sobriety and all the other tests that preceded. It was the bloodshot eyes. It's the smell of alcohol. As he approached the person sitting next to the vehicle, the officer had enough probable cause or belief that this was the individual driving the vehicle. And then you add those facts with the statement, that's sufficient. The case law, like I said, Your Honor, is if there's independent circumstances, which there are here, there's independent facts besides the admission. The corpus delicti is if he was just sitting there and he makes an admission and that's the only facts that there are, then the argument may be a little more credible. Where the argument's deficient is there's other facts that the officer relies upon, which are in the police report for going forward with the field sobriety and then ultimately the charge of the OWI.
Have I let you finish, counsel?
Judge, I'm concluded. Thank you.
Thank you. Have I let you finish?
You have, Your Honor.
All right. Defendant Justin Posac is charged with leaving the scene of a property damage accident in violation of Michigan law, specifically MCL 257.618, as well as operating while intoxicated with a high VAC, also known as a violation of the super drunk law, contrary to MCL 257.6251C. There's also a third charge of refusal of the PBT. Defendant has filed a motion in limine seeking exclusion of certain statements made by defendant on the basis that such inculpatory statements violate the corpus delicti rule. Defendant argues such statements, i.e. that he was the operator of the vehicle on the date in question, are inadmissible because the people cannot establish the corpus delicti of the charged offenses through legally admissible independent evidence. For the purposes of this motion, the Trenton City Attorney and the defense attorney, Mr. Bologna and Ms. Barkovic, respectively, stipulated the facts contained within the police report. On July 27 of 24 at 10:18 p.m., Trenton officers were dispatched to the area of Lodge Lane and Long Meadow Drive in the city of Trenton for a vehicle that struck a parked car and was attempting to leave the scene. Drive, a 2023 Chevy Silverado was parked across the street with only 3 wheels. The right front passenger wheel was missing. Officer Hughes made contact with the male, Justin Posac, as well as a female, later identified as his wife, Rochelle Ham. Officer Hughes asked Posac if he was involved in the crash. Posac stated, "I was driving, then I blacked out, and now I'm sitting on the curb." Defendant Posac acknowledged he'd been drinking that evening. Hughes observed the defendant during their interaction have slurred, slow, deliberate speech and glossed over eyes. Field sobriety tests were conducted, including ABCs, counting, one-leg stand, walk and turn, and HGN, none of which were successfully completed by defendant. Defendant refused the PBT and was placed under arrest for OWI. He agreed to take the breathalyzer test at the police station. After the 15-minute observation period, defendant provided 2 breath samples. Defendant was ultimately charged, as I said, with OWI, leaving the scene, and PBT refusal. And at some point, Lyons Towing had towed the defendant's vehicle, the Silverado, I should say, and the 2015 Chrysler that belonged to the victim. The defense, citing People versus Shoemaker at 276 MA Mishap 165 2007, argues that, quotes, in a criminal prosecution, proof of the corpus delicti of a crime is required before the prosecution may introduce a defendant's inculpatory statements. Introduction of defendant's statements to the police under the corpus delicti rule. However, in Shoemaker, the court stated, in a criminal prosecution, proof of the corpus delicti of a crime is required before the prosecution may introduce a defendant's inculpatory statement, citing People v. McMahon at 451 Mish 543, 548, 1996. The corpus delicti rule is designed to prevent the use of a defendant's confession to convict People v. Conrad at 449 Mish 263, 268, and that's a 1995 case. The court went on to state, under the corpus delicti rule, a defendant's confession may not be admitted unless there is direct or circumstantial evidence independent of the confession establishing the occurrence of the specific injury and some criminal agency is the source of the injury. And that's with respect to that same case at 269 and 270. The court went on to state, quotes, proof of the identity of the perpetrator of the crime is not part of the fact that do not amount to a confession of guilt. And that's citing People v. Rockwell at 188 Mishap 405, 407. If the fact admitted does not of itself show guilt, but needs proof of other facts which are not admitted by the accused in order to show guilt, it is not a conviction. But here, he admitted he was driving. We had somebody clearly involved in an accident. It's not customary to see a car parked on the street, especially after officers have been dispatched, that has 3 tires still on, 3 wheels still on the vehicle, but the right passenger wheel off and missing, the defendant standing or sitting at the curb across the street, and then his admission that injury, there was certainly direct or circumstantial evidence that there was an accident involved, and that as a result, after the officers also verified pursuant to what I already said, that is the fact that there were all these tests done, he refused the PBT, not so much that, but the field sobriety tests were conducted, and he smelled of alcohol, eyes glossy, etc. Did not successfully complete any of them. And then pretty much in order. You have the same situation here. So I'm going to find that the corpus delicti rule does not bar admission of the statements that he was drinking, or specifically, more importantly, that he was the driver of the vehicle. At trial, if it goes that far, you better check. I haven't looked in a few years. I haven't had the issue come up, but I don't think you can use any of those statements from the wife, even if they're not hearsay or do not constitute or do not fall under an exception. Still in effect, I'm sure it is, where you can't compel a wife to testify against your husband. So that is where husband against his wife. So that's my order. You guys, I'm going to deny your motion. You guys have trial coming up on the January 10th. Instructions are due by December 27th. Will either one of you, do either one of you care to pre-try this now?
I
Judge,
think we'd like to talk
separate, can we have a separate?
I don't have my.
You should be. He's here the 19th, right?
Yeah, that's our next date.
This is my docket day with you, right?
It is your docket day. I don't have my. I
Judge,
think we'd like to talk.
Can we have a separate?
Docket day with you, right?
It is your docket day.
We'll set a final pre-trial, Ms. Barkovich, and I'd really like you here on this date if you can be, okay? December 19th. Let's figure out a time when everybody can be present.
Camilla, I have time now if you want to discuss it. If not, we can wait.
I'm going to need
actually, I got something else too.
Absolutely.
What are you going to need?
I'm going to need time. Judge, do you have the afternoon that day?
I don't. I could make it 9:30. You're a busy lady. I just don't want to make the prosecutor wait until the afternoon is all.
Thank you,
It's
Judge.
not
I'll
fair to
see if
him.
I can move some stuff around. If
You
not,
want me to make
then-
it 10:30, 10:30, 11? I can do any of those for you.
I will see if I can move things around to be there at 8:30. If I can't, then have a resolution that day.
All right, let's make it final pretrial, December 19th at 8:30.
Thank you, Judge.
Have a good day. Good luck, sir. Wish you well. Thank you.
Thanks, Your Honor. Good
Thank you.
argument, Camilla. It was very creative.
Sure. Thanks. It sure was.
Thanks, Judge.
Thank you. I won that. Ms. Barkovich, you still there? I don't remember what case, but I remember winning one on corpus delicti over 30 years ago when I'm still a lawyer.
That's a good one.
Devin Margaret Sessoms.
All right, kids. I'm not doing that anymore. That whole last part of the docket right there was all messed up. I did a lot of work trying to get that case put together properly, but apparently when I went into the editing process, this is my theory. What happened? That all of those little jumps and things caused the rendering process to actually knock the voices out of sync, which was equally as annoying as all of those little jumps and breaks. So that's the danger of of what we do sometimes. Sometimes it just doesn't come out clean. Do the best you can. It still doesn't come out clean. Man, that was rough. But hey, what an interesting case, right? So that guy, for anybody who didn't pick up, that guy actually gave admissions, but she was trying to argue that there were other people around, that the police officer shouldn't have targeted him for whatever reason, but you know, she was getting all of that from the body cam footage, not from his actual report that he wrote. And the judge read off a whole lot of case law that basically stated that the officer had judicial or had the ability to make determinations on how to issue his investigation properly, and any self-incriminating information that this individual gave to the officer during the course of an investigation, whether she felt the investigation was improper or not, was still incriminating, and it was still applicable for the purposes of trial, which they are going to have a pretrial conference on the 19th. So, trying to wrap all that up because I know it was all broken up and kind of crazy and stuff. So that's. I am your Lone Wolf Usul. This is the things we do, and chat's been awesome, and I appreciate all of you. We'll be back live Monday night if Fleischer's live. We're going to be live any night that Fleischer's doing a docket, doing our 2-hour-long Fleischer Forum, talking about what happens during the day in Harris County. And every day of the week that there are court cases, I am wrapping up court cases, putting them in little packets, and just slamming them out there for everybody to watch in nice little boxed up, bite-sized portions. I hope you all take a look at some of those independent videos that come out aside from our live productions here. I hope you enjoy them as much as I enjoy putting them together. And everybody go check out Sammy the Chinchilla. I'm not gonna lie, I like the little animal videos, and I've happened to cross Sammy the Chinchilla once or twice. That's happened. I'm humbled to have you in our chat with us. Thank you for coming by, Miss Christie, Chinchilla Mama. Ladies and gentlemen, I am David. I am your Lone Wolf Usul. I am your host. I am your curator for these videos at the Court Gallery. I am the host of the Weekend Review and the Fleischer Forum and any other live shows I decide to put out because I'm crazy like that sometimes. Ladies and gentlemen, I hope to see you again. Hope to see you at the Fleischer Forum, maybe. We'll be getting together. That's at 9 p.m. Eastern Time every weekday. This show right here happens every weekend at 12 p.m. Eastern Time on Saturdays. So join me every weekend, same Wolf time, same Wolf channel, for the Weekend Review. And I'll see you during the week at the Fleischer Forum. I love you all very much. Thank you all for your support this week. Thank you all for your support every day of the week. You're all wonderful. I am humbled to be your servant and present these videos for you. Y'all have a great Saturday. We'll see you next time.
All right, this is a matter of the state of Michigan versus.
The whole thing's all messed up. Love you guys. See you later. Bye now.